Hi, this is Advocate Afreen Hossain, currently practicing at Alipur Judges Court, Kolkata, and it's really good to be back in front of the camera after such a long time. Now, if you've grown up in India like me, you must be knowing that the topic of divorce has been a little hush-hush. So while growing up, we were not really educated about the topic of divorce, and the stigma of the society coupled with the elaborate procedure of undergoing the divorce made the entire subject really difficult, and hence the hush-hush. In the earlier days, men and women would prefer to be in a soulless and dead-end marriage rather than to face the legal repercussions and the stigma of the society regarding a divorce. However, it's 2023 and things are not the same anymore. So in today's video, let's talk about these changes regarding the divorce laws, which has made the entire process hassle-free and a lot helpful for the couples who are seeking it. Divorce is the legal end to any marriage. Well, the thoughts and beliefs regarding the marriage system keeps changing with time, and so do the rules for divorce. The rules for divorce gets modified with the need of time, and hence in 2023, it is very important to be updated with the rules of divorce. Well, in the earlier days in India, there were not many cases for divorce, but in the modern times, it has been observed that there has been a change in the mindset of the people. So come, let's talk about the new rules which have been amended regarding the rules of divorce. Number 1, waiving the mandatory 6 months period of rehabilitation. According to Section 13B Clause 2 of the Hindu Marriage Act, when a couple moves to the court for divorce with mutual consent, the court grants them a mandatory 6 months period to consider any chance of change in their decision. The court usually grants the period with the intent to save the marriage. Usually after the 6 months of period, the couple either reunites or moves on with the divorce. The rehabilitation period was mandatory earlier, but according to the new rules, it is not mandatory anymore and is at the discretion of the court. The court may decide as per the facts and circumstances of the specific case that whether the couple should be granted a period of 6 months for rehabilitation or whether the couple should be allowed to divorce immediately. This was observed in the Supreme Court ruling of Akanksha versus Anupam Mathur case. In this case, the court was satisfied that the couple had taken a conscious decision to divorce and there was no requirement for the couple to wait for another 6 months to divorce. Hence, the court waived off the 6 months rehabilitation period and immediately granted the divorce to the couple. Number 2, irretrievable breakdown of marriage is now a valid ground for divorce. When a couple decides not to live as married partners, then it is called a separation or breakdown of marriage. The couple may or may not live under the same roof, but they definitely don't live as husband and wife. There are no such rules regarding this issue in the divorce law. It is a matter of the court's discretion that whether the separation can form a ground for the divorce. If the court sees that the couple is completely unwilling to live with each other, then the court can allow them to proceed with the divorce. Number 3, law of maintenance extended for living relationships. According to the Hindu Marriage Act 1955, the court orders for the payment of maintenance post-divorce. This is just to help women to maintain the same standard of living even after divorce. Well, the marriages which are not under Hindu Marriage Act, the women are eligible to claim maintenance under Section 125 of the Code of Criminal Procedure. The live-in relationship is treated as a marriage in the eyes of the law. Therefore, a woman who has been in a live-in relationship can claim maintenance from the live-in partner under the Code of Criminal Procedure. As per the new divorce rules of 2022, the victim, that is the wife or the live-in partner, can claim maintenance under the Protection of Women Against Domestic Violence Act 2005, even if the victim is not eligible for the claim under Code of Criminal Procedure. The victim woman can in fact claim a higher relief under the DV Act rather than what is contemplated under the Code of Criminal Procedure. Number 4. adultery is not punishable, but it is a ground for divorce. The courts observe that by punishing the spouse and his or her lover with whom he or she indulged in the adultery cannot be a remedy to save the marriage. Hence, adultery can be a ground for divorce, but adultery is not punishable. Number 5. Triple talaq cannot be a ground for divorce. As per Muslim law, merely pronouncing talaq 3 times can be a ground for divorce in India. This is very unfair to Muslim women because it gives the right to Muslim men to unilaterally dissolve the marriage. The arbitrary practice of triple talaq is against the rights of women. The practice of triple talaq has been declared unconstitutional and has no significance in the eyes of law according to the new divorce rules. Number 6. Divorce under personal law cannot override the power of the civil court. The order of divorce can only be granted by the civil courts. If the Christian church or any other personal law grants a divorce, such divorce shall be considered invalid. The apex court in Molly Joseph versus George Sebastian case declared that any competent court can only do dissolution of marriage. Hence, the order or decree of the civil court shall prevail and override the order of any personal laws. Thank you for watching today's video, and I hope this video was of help to you. If you need any kind of legal help, my contact details are given in the description box below, and I'll see you in the next video. Till then, like, share and subscribe.